couple of questions here. I'm going to start with James Lee. James, you address this first, and Pablo, if you would like to weigh in, please feel free to do so. So, James, patent term adjustment is granted because of delays in the patent office. That adjustment is reduced by the applicant's failure to diligently prosecute its application. Doesn't that suggest a lack of gamesmanship?
I think if we take a look at the court's decision in Breckenridge, one of the reasons why it decided that obviousness type double patenting need not apply there was because the longer term that existed there happened due to an intervening change in patent law, allegedly that the patent applicant in that particular case didn't really do anything wrong, wasn't trying to structure their patent terms in order to try to get a longer patent term. It could potentially be similarly argued that because patent term adjustment here is by itself already taking account that hey, if I have gamesmanship during my application, if I have unnecessary delays, if I have unnecessary continuations, that will decrease my patent term adjustment. That perhaps patent term adjustment already takes into account a lack of gamesmanship and should suggest that obviousness type double patenting does not apply. So I think the answer there is yes.
Pablo, do you have any thoughts on that? Would you like to weigh in? Okay, James, I have time for another question for you briefly. Isn't there a procedure to correct errors in Isn't there a procedure to correct errors in inventorship?
The answer to that is certainly yes. In my discussion of joint inventorship, it should be made clear that there are ways, for example, if I have a patent and there is a very strong allegation that the inventors are named incorrectly or that additional people need to be added to those inventors, there is a procedure by which you can correct inventorship for an issued patent. However, when that happens, there will always be potential additional challenges. For example, if I add an individual as an inventor, perhaps now I have additional obviousness type of patenting allegations. I can have also other allegations of invalidity that always have to be addressed. This is why getting inventorship correct and being able to argue when individuals are inventors and when individuals are joint inventors is very important to keeping patent term.